I'm like Director Cordray to return to that quote that I mentioned earlier in this hearing, Sheila Bair's observation that banking agencies' assessments of risks to consumers are closely linked with and informed by a broader understanding of other risks in financial institutions, placing consumer protection policy setting activities in a separate organization, she said, apart from existing expertise and examination infrastructure, could ultimately result in less effective protections for consumers. I'll just ask you if you agree in concept with her concern there.
Well, I hadn't heard that quote before, and I found it curious because the FDIC, in fact, has reorganized their own staff to separate consumer protection staff from other staff so that they can make sure they have a more direct focus on these same issues. So they've kind of mirrored Dodd-Frank.
But remember, the quote here is in a separate organization.
Yes. Okay.
And that's her point.
Yes. I actually think that the two issues go hand in hand. I don't think that you can have a safe and sound financial institution that is not treating its customers in a sustainable basis for the long term. If they're eating their customer base by exploiting them in the short run, which is the kind of things that raise consumer protection concerns, they will not be a safe and sound institution in the long run. So I think there's much more harmony between these concepts than people have recognized. I also think, though, and I would agree with you, that it behooves us to collaborate closely with our fellow regulators to make sure that we aren't inadvertently, we certainly don't intend, inadvertently undermining anything about the safety and soundness of the financial system, which would also disserve consumers.
But of course, however, since we've lost the argument for inclusion in one organization or in one entity for these functions, so that, as she pointed out, you could share that information and have that broader understanding of other risks in financial institutions in terms of your decision making, would you agree that the authors of this bill went to great lengths during deliberations to ensure that you were not required to consider safety and soundness?
Well, I'm not sure I would agree with that. Under the new law, I sit as part of the Financial Stability Oversight Council along with my fellow regulators. What's called the FSOC has the ability to override our rules if they threaten the safety and soundness of the system. I think that means that we'll have to and should want to take that into account as we write rules, and also seek out and hear their perspective and have that inform us. Again, I'm sorry.
Right, with a super majority vote. I would point out that perhaps the reason I am focused on that issue of not considering safety and soundness is because I tried during the markups, during Dodd-Frank, to have that included and failed in that endeavor. But let me go to another concern that I have here, and it has to do with the CFPB will now have the authority to rule whether a state law is inconsistent with federal consumer protection laws. And I was going to ask, what standards will the CFPB use when exercising this authority? Because if little is done in terms of keeping the states on the same page, then we could end up with a patchwork of varying consumer protection laws. And would you agree that that would be bad for consumers and businesses?
Well, I think we've had a patchwork of consumer laws in this country for decades, and it's, another term for it is federalism, both court law
or maybe Articles of Confederation would actually be the term for it, because there are exceptions, like in the insurance industry, where we do have 50 different regulators, 50 set of rules, 50 sets of separate markets, and a consequence to loss for the consumers as a result, and loss to businesses. But the real reason we gave up on the Articles of Confederation and tried to go to one national market was to avoid just such a comeuppance, because that is what was so costly pre-Federalist system. The idea under the Federalist system was that we were going to have at least one national market. That's not where we ended up, and that's where I hope that rather than compound this problem, which I think Dodd-Frank will do, you might work in the other direction to create one national market.
Gentleman's time has expired. Mr. Westmoreland.
Should I respond to the Congressman, or
Quickly.
not respond?
Quickly.
One of the things that we're supposed to do is ensure coordinated enforcement of the federal law here. Dodd-Frank was unusual in allowing states to enforce the federal law. We want to make sure that we aren't going in 50 different directions on federal law. As for state law, we're inclined to be respectful of the states. As we have situations, or if they come to your attention, you want to bring them to our attention, we'll be very interested in hearing about concerns in that regard.
Thank you, Director.